5:30, it's a tax battle that's going all the way to the United States Supreme Court. A local law firm calls it a fight over the right to privacy, and they're taking on the IRS. The U.S. Supreme Court only hears a small number of cases a year, just 47 in 2022.
So as you can imagine, getting a case heard can be very difficult, but a local law firm and one of its customers got the justice's attention. Local 4 business editor Rod Maloney is live tonight with a look at the case and how it came about. Rod?
Well, here's the thing. Here's the book. They make these specialized books for the Supreme Court. Want to make sure they get all the I's dotted and T's crossed. But here's the thing. It's a law firm. Maurice Rose is the lawyer. We're going to hear from him in a second. But he says, how would you like it if, say, you had an attorney and, say, your wife and you owed some money to the IRS and the IRS went after your law firm's bank records and your wife's bank records and then not tell anybody about it? Should they be able to do that? In his estimation, the answer is no, and that's what's all about here in this case.
The IRS shouldn't have unlimited ability to go on a fishing expedition among individuals' personal records.
Lawyer Maurice Rose didn't even know the IRS had gone after his firm's banking records until his banker mentioned it. It led him to wonder.
There's no way of knowing how many times, although it's not an uncommon practice from what we understand, where the IRS would, in our opinion, overstep its bounds to try to go on a fishing expedition.
And remember, we're talking here about some information that could possibly be privileged between a lawyer and a client. Rose sued the IRS back in 2019 and lost, appealed and lost again at the 6th Circuit Court of Appeals. Here's what it said in the decision now appealed to the Supreme Court. Quote, in pursuit of over $2 million of taxpayers' unpaid liabilities, the IRS issued administrative summonses to the banks of the taxpayer's wife and lawyers, petitioners in this case. The IRS did not notify petitioners of the summonses, relying on relevant provisions of the Internal Revenue Code excluding summonses issued in aid of the collection of tax assessments from its notice provisions. Petitioners were not entitled to notice.
They want to see how he's paying us.
Rose and his lawyers will argue in D.C. that this is a practice that needs to end immediately.
Let them explain to a judge why it should be relevant and why it's not privileged and why should they have a right to it that would trump someone else's privacy rights.
And so they go now before the Supreme Court on March 29th. We reached out to the IRS to get their thoughts on all of this. They say, hey, we don't comment on pending litigation, so we'll have to wait until then. Reporting live, Rod Maloney, Local 4.
An interesting case, one that I know you will be following. Thank you, Rod.